Hello and welcome to Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the people of the state of Indiana versus Richard M. Allen. And I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So, part two, Brad Rozzi. We had a little technical difficulty there. You got it figured out on his end. He looks ready to go. He's wearing a mighty fine sweater vest. So let's pull him on. What's up, man?
Not much, Bob. How's it going?
It's going well. You got all your you had to grab your daughter's computer, huh? I mean,
yeah, I had to transition to this MacBook or whatever, this kitty computer. And so they're trying to tell me what to do here because I've never used one of these things. They use these things in kitty land, and I'm a PC guy. So anyway, is the image pretty good?
Yeah, the image looks it's better than the last time. Like you were a little cloudy last time. Like that's why I was telling you to maybe.
That PC camera can't stand up to the Mac.
Yeah, man, that Mac camera's got it going on, man. Like you're in the modern era now. Like you've come out of the Stone Ages. You're now with the normal people who all have MacBooks. Just so your daughter knows, Allie and I both have MacBooks. So
it was a treacherous turnover forced upon me, and I fought it, and it was the worst thing I could have done for the office because all the discovery that I get is incompatible with Mac. Like nothing I get from a police department, lots of stuff from the FBI. I have to like go through this whole special rigmarole. It was so horrible, but we flipped the whole office and like couldn't go backwards. So.
Yeah. I think you're either on or you're off. There's no in between with this stuff, and I'm sticking with my regular PC. I actually just got a brand new one about I don't know, maybe 3 or 4 days ago, and I have used it though. So I thought it was going to work fine today, but I got it because my camera was shot. So I was ready either way, but sorry about the technological problems.
No worries, man.
Let's get on with it.
Let's get on with it. So you've been making the rounds a little bit. How have you been enjoying it? Have you been enjoying talking about the case a little bit or not so much? Like where are you at with it?
I think that, a little bit of both, honestly. I mean, some of it just depends on the timing of the media appearances. Sometimes they're more convenient than others. And so, when they're convenient, it's fine. But when they're not, we're all trying to make a living. Again, we've talked about this before, but, I kind of eat what I kill here in small town Logansport, and then, work in almost all of the surrounding counties and then, counties beyond. And, we're all back to trying to make a living. And so, kind of weaving all this into the middle, that's been difficult, but there's a purpose behind this. And it's to continue to advocate for the client and to help people, understand and, for those that aren't aware of what's going on, kind of those that are new to the game, to, help them understand that we've got a situation here where we've had an abuse of power or an abuse of authority. We've had a guy who was wrongfully detained in the most unusual of circumstances. We were playing on a field that was not level in terms of the way we were being treated, and And, you know, we were not permitted to put on a third-party defense, and those are all really important aspects of this case that continue to be important aspects through the appellate phase.
And speaking of which, I'm just going to lay it out there right now. Like there was a major filing today. I want to let people know and try to have them understand that that is now a pending motion. Brad is one of the attorneys of record on that motion. They're not going to be able to talk about that motion. I know that motion created a lot of questions out there. Believe me, we would love to be able to chat about it. I'm sure Brad would love to be able to chat about it. Bottom line is they can't. So you're not going to be able to, we just can't dive into that. There's plenty of other stuff that we could talk about without getting into that. So before you guys get frustrated in the chat and you're wanting to have all these questions answered, because I can already see them, you know, we're not going to be able to delve into that, sadly. That'll be for a later day.
Yeah, I appreciate that, Bob. I would say this. I mean, look, you know, these cases, especially this one, because of the volume of information that's available and that's been offered up and, you know, by the state and discovery, and because of the volume of information that's out there on social media, these cases, they continue to evolve. This one's evolving at a very quick rate, and we're learning new things every day. I probably got, you know, I'm trying to be somewhat accurate. I'm not trying to over exaggerate, but I probably got 5 or 6 emails today that had some substance in them, just from kind of random people. A few of the email addresses I recognized. They're kind of, you know, daily contributors, but there were a few others that weren't. I got a couple of cards in the mail today. I may not get any at all tomorrow, but I got a few in the mail today. And that, you know, that also, sometimes you get those and there's information in those that you're consuming. And so this is just ever evolving. And, you know, unfortunately, you know, we didn't prevail at the fact finding, you know, phase, at the trial phase, but this appellate phase is very complicated and also, you know, has many layers to it. And even looking ahead beyond the direct appeal, in the event we're not successful, there are more avenues available to us later. And you got to think about all those things when you're in this business. And so a lot of this, a lot of the post, you know, trial work is focused on that. You know, what's going to happen 2 months down the road, and what's going to happen 6 months, 8 months, 10 months, and maybe even 2 or 3 or 4 or 5 years down the road.
Yeah, right. Exactly. And the one motion that was important, it's not going to get the publicity, obviously, that the motion to correct errors, but you know, the second motion asking the judge to order the preservation of evidence, as to your point, is absolutely critical in a case like this for those types of, if this isn't successful on direct appeal and it doesn't get remanded and you don't have any luck with the Supreme Court, and it turns into a post-conviction relief act type petition, you know, that's where you're coming with newly discovered evidence and all those kinds of things. And you want to have evidence that probably should have been tested the first time around that wasn't by the state. You know, you need that stuff all preserved. So to me, it's a no-brainer. You know, she came with the, you know, lack of specificity in your original request to preserve it. You know, I think the simple thing would preserve it all, Judge.
Right.
That's a safe thing to do.
So I wanted to ask about the confessions, and I don't want to harp on them long, but you were able to get into the record a first call from the, you know, what those calls that their state is calling the confessions. There was one earlier that very same day that the judge didn't allow you guys to get in, but you were able to put it on the record. It is a matter of record. Can you tell us what was in that first call?
Yeah, so you're going to test me already, and again, my memory with some of this stuff is just I'm no Andy Baldwin, so forgive me. Yeah, so there was a call from, I think it was around 3 a.m. The initial call on April 3rd, 2023 was around 3 a.m. if I recall, and that call was made from Rick to his parents. And in that call, There were communications that were, I think our team felt that were very telling. And it was more like, it was the setup to a false confession. Basically, it was like, hey, I'm not feeling right. Something's not right here. And, that I would never do anything like this, but something's just not right. And I'm scared, I'm worried. And then, you have the call ends. And then of course there's a call 2 or 3, or maybe, I don't know, an hour or 2 later. I'm sorry again. I don't know.
No, we won't.
I think it was around 6. I think.
Yeah, I have to get my notebook. But there's a call made a couple of hours later, and then Rick says some things that are incriminating, but he's still kind of waffling, like, hey, I don't feel right. Something's up. I guess if I did it, I did it. That kind of stuff. So I think what I need to explain is that there was a transition from, that I wouldn't do anything like this, which was the first call, through these incriminating statements, which came later in the morning. And then ultimately another call beyond that, where there was, some, I guess, retracting of that, or it wasn't really a retraction. It was more of, what did I talk about this morning kind of thing.
What did I say? I don't even remember.
Kind of thing. And I just thought that it was important for the jury to hear the whole story. Context always matters. You're putting experts on the stand to talk about the ingredients, so to speak, of a false confession. And, you had a lot of this, I might have, I think I could have, maybe I did. And of course, the state views those as outright confessions. But if you look at the true words and you kind of see the bigger picture, the context matters. And,
And I had looked at the rule in Indiana for the completeness doctrine, and this fell directly in that doctrine. So I hope it's one of the issues. There's so many, I guess, for appeal. Who knows if they'll all be able to make it. But to me, it's an important issue for an appeal, because it specifically talks about giving context, and it being even an earlier writing or an earlier recording, whatever the case may be. It seemed to squarely cover this situation.
And Brad, when he argued that, read the rule verbatim to the judge, and he was right in terms of the justification of playing that earlier recording, but Judge Gull did what Judge Gull does, and, she made her ruling and Brad moved on. So, like, in terms of your kind of thought process, like, kind of try to walk us through this from the attorney's perspective. When you've got that situation where your clients started to talk and has said some things that could be considered inculpatory, and then you get this kind of volume. Like I can't remember a time where I've seen this kind of volume. And granted, they're calling 8 times that he said the word "I did it" a confession, even though it's all in one call. So, but what was your thought process on how to attack these confessions from the legal standpoint initially?
From a legal standpoint or from a factual standpoint?
From both.
Yeah. So, those are 2 different, analysis. From a legal standpoint, of course, the thing that you're looking at is, well, wait a minute, how did he end up here? Or should he be here? How did he end up here? What are his circumstances? Is he being afforded all the same rights that someone else who's charged with similar crimes would be afforded in a county jail? Those kinds of things. And then you just get back to the safekeeping statute and the due process argument about, which is, look, basically, a sheriff signed a piece of paper and handed it to a judge, and they threw him in a van and hauled him off to Westville. And there just really was no due process. And, we've made these arguments. I think they're all very public. I'm not going to get into all the minutia, but, so from a legal standpoint, you're just like, wait a minute, how do I challenge this?
The voluntariness of it.
The voluntariness, which again is a 2-pronged test in Indiana, whether or not these statements are voluntary. And if they are, then the jury gets to determine the credibility of the statements. And of course, we did not prevail at the first phase or the first layer. So we ended up with the second, and we didn't prevail there either. And actually, I'm not really sure. I think, with this juror who came out and allegedly provided this information to one of the other podcasts. You know, I read the transcript, obviously, and I certainly appreciate any information I can get. I'm not sure if I got a lot of clarification out of that in terms of what weight the jury gave the statements. I mean, I felt like they were open-minded based on what I read. They were pretty open-minded. It wasn't, it wasn't the nail in the coffin kind of thing.
Right.
Yeah.
Maybe I misinterpreted that. But
No,
I mean,
I think at some point she almost said that they almost disregarded the confessions.
yeah.
And the bullet. So you're too, even though she found you to be very intimidating and terrifying as an attorney,
but not grossly negligent. So I feel like that was a step up.
That's true. But both of your cross examinations and your witnesses that you put on were effective in the sense that they did not put a lot of weight on either of those two things. I mean, they definitely said they didn't really consider it. Yeah, they discounted it.
Yeah, I mean, this is one juror, and I always I'm always cautious about kind of jumping to conclusions and essentially imputing that on everybody else that was sitting in the box, because you know how jurors, they all have their own opinions. And so I really am interested in kind of getting a cross section. If I heard 4 or 5 of them, I would be a lot more comfortable. I don't need to hear all 12 of them. 4 or 5 would be fine. I'd feel more comfortable that we're getting the truth. But, I guess to answer your question, so, the legal arguments are what they are, and that's all pretrial stuff. But the factual side of it, it really is it gets back to being a lawyer, a trial lawyer, and that is really developing facts. And that part of that in this case was just, watching video and listening to audio and understanding what the circumstances were around him. And that means, I went up to LaPorte, Indiana one day, and I probably took 8 or 9 depositions by myself one day of prison guards, prison staff members, I think an inmate or 2 we had transported. And, most of those people their involvement was very limited. And, it was something that may have occurred over the course of an hour in one day in Rick's detention. But all of those people help kind of fill in the gaps and help paint the picture about what was really going on a bigger scale at Westville. And so that's how you develop facts. And so that's kind of what I tried to do to tell Rick's story, because it's so difficult. It's one thing to tell the story of somebody who's been accused of a burglary and, they're out on bond and they're just one of the local schmokels in town that's been accused 3 or 4 times previously, maybe convicted. I mean, that's just kind of normal life. But when you're detained in a place like he was detained, and you've never been in a place like that before in your entire, 51 years of existence, and normal people can't go into a place like that. Even lawyers can't go into a place like that. You and I can't just walk into the DOC like we can a county jail.
Right.
And start milling around just so you can see what our clients are dealing with. County jails, you can certainly get in the front and in the waiting rooms and, sometimes and in the visitation room. Sometimes I'll get in the back of these jails if I'm meeting with clients in a special area, maybe where we're working in person, in the flesh instead of through a glass. But getting into prison, and especially in the Westville Correctional Unit, in the back, so to speak, in a detention area, it just ain't happening. So you got to tell the story of what it's like to be in a place like that through other people.
Right.
And so that's what I tried to do.
Which is really tough in a prison, over the course of the last 2 years, when trying to explain to people, that you've got this issue where you're never going to be able to get guards to start ratting on themselves or ratting on one another in terms of what they're doing, saying, or not doing with respect to Rick Allen back there. And, that's part of your challenge in terms of developing the facts, is that it's really tough, because you don't get to peek behind the curtain. You never get to see the Wizard of Oz back there, because that's just how they run prisons, and I thought that Gallipo was such a shining example of somebody who was completely full of shit. I mean, the fact that he lied about something is relatively mundane, is whether or not that camcorder had sound the first time that you had him on the stand during the safekeeping hearing in June. was very telling to me. You know, I mean, to me, that showed exactly what you're dealing with when you're dealing with trying to figure out exactly what's going on with your client. And you have the additional encumbrance of the fact that Rick's just not right in the head at that point. So it's not as if you can really just ask Rick, you know?
Yeah, and you're not, I mean, I don't know about you, but with clients, no matter who they are, you acquire information from them when they're in jail or even when they're out, but it's always trust but verify, right? Like, that's just the way I'm wired. I mean, I'm not going to just throw a bunch of information on a pleading just because my client told me, hey, A, B, and C occurred. So you just throw A, B, and C on a pleading and file it with the court. I mean, that's just no way to maintain any credibility with the,
Right.
with the judges that I work with, at least on a normal basis. So those are all challenges. And I mean, at that point in Rick's incarceration, he and I hadn't really developed a true bond yet, from an attorney-client standpoint, from a trust standpoint, because it was early on, and sometimes it takes, I mean, I hate to say years, but, it takes months and months to build an attorney-client relationship that's founded in trust. Especially for a guy like him who found himself in the middle of a tornado, and he landed in a place that he was totally unfamiliar with. I mean, I don't think he trusted anybody, and I don't blame him other than Kathy, basically.
Yeah. And
it just takes time.
it does. And you've got that added element of the fact that, again, he's got mental issues that are starting to develop beyond what he came into that facility with. That is like a real added challenge for you in trying to figure out what's what, and like you said, I mean, the bottom line is you've got a guy who's ripped out of his life that he's known for the last 51 years, and who is a guy who Westcott, I thought her testimony was very compelling about, this other kind of mental illness that he had in terms of this dependency that he has on people, and just constantly needing to be propped up by Kathy, to be ripped away from her and them cutting her off from him in particular was devastating to him and to his mental state, and I think that you did a wonderful job of being able to get that out there, because we had a similar situation with our client in Omaha, and it was really frustrating, and we didn't have as much luck in terms of being able to exhibit what was going on. And that was a county jail, but he was treated very much as if he was in prison, with a lot of the same kind of techniques that they used with Rick in there. So yeah, I mean, it was challenging. The thing that I wanted to ask you about was, like, Allison and I had a lot of conversations about kind of attacking the voluntariness of the confessions, and kind of making the decision to kind of say, all right, I'm going to do the global approach, as opposed to attacking them one by one. I'm going to attack them as a whole, which was a really novel argument, and one which I really liked, and which I thought fit, because there was no way to do it, because this isn't your typical, I'm shining a light on you, I'm going to grill the shit out of you for 10 hours until you crack. This is something that took place over a period of months. And it was like the confinement conditions were the interrogation. You're just subbing out that bright light and them not allowing you to sleep. And you're adding all these conditions together, and that creates the situation where he finally cracks.
Yeah, it was a psychological squeeze basically over time. And yeah, that was a conscious decision. I mean, look, one of the problems that we were having is that we really didn't know what was out there in terms of statements. It just seemed like, we would work through discovery and you would find another reference to something incriminating every other day. And so for us to have a hearing and, let's just say, take on 20 of those statements individually, that would be great if we could do that and if we were successful. But then another 2 or 3 might pop up, a day or 2 later. And so, or maybe you overlooked one. I mean, again, because we're dealing with such volume in terms of discovery, it's not like somebody was handing this information to us with these statements, archived or chronicled, or, calendared or diaried in some, consumable format. It's like we're picking this stuff out. And so there were times I'm like, I'm not even sure the state knows that this exists. I mean, I think they did, but I'm not sure, because I didn't really know exactly what Harshman was doing at the time either. You know, I didn't understand the comprehensive system of surveillance that they had on him at that time. Those things were things that I learned over time, or we learned over time, by taking depositions and doing discovery. That stuff just doesn't happen at the speed of sound.
Right.
You know, it's a slow process.
Do you think, as you sit here today, that you actually have a fair accounting of when he was started to be given like involuntary medication and how that correlates into statements made? And I ask this because I know a lot of our listeners have questions about, is being involuntarily medicated a factor when looking at whether the corresponding statements are voluntary?
Yeah, I feel like, you know, now we have a pretty good idea of when he was being medicated. And I think the record, you know, was fairly robust once we were able to find it all and organize it, and, you know, and then analyze it. Because again, you're getting this stuff in segments. You know, you do these discovery requests, and, you know, every now and then they send you something, and then you look through it, and then you send another request out. It's like, wait a minute, are the dates corresponding? Did we miss a week here? I know all that seems like it would be fairly easy to the layperson, maybe, just to keep track of all this and journal all. But when you're in the heat of battle and you're trying to take depositions, and, you know, you're trying to travel to see your client, and, you know, you're preparing for deposition. I mean, there's just so much going on. And with the small team we had, we were doing the best we could to try and stay organized. But part of the challenge of staying organized, one of the things that we struggled with, was keeping track of all this prison data. 24 hours a day, there was video being generated. So, you know, as a lawyer, it's extremely uncomfortable. It's an extremely uncomfortable situation to not know what's going on all 24 hours of that video. But can you really watch it all? You know, do you really have enough hours in the day? You don't. So to answer your question, I think we had a pretty good record by the time the trial was over, but a lot of this was kind of bump and run. You know what I mean? You're kind of learning as you go. And some of that was, you know, right before we started the trial. Some of it was, during the trial. And some of it's even been afterwards. So yeah, I do think the record's there. It's just a matter of organizing it, you know.
And then, legally speaking, is there a relationship between, is it a factor when determining voluntariness of the statements, whether or not the defendant's being involuntarily medicated?
Yeah, I definitely think that's a factor. And, you know, looking back, if I would have had a chance to do this over again, obviously, I think one of the things we would have done is probably put more, you know, hardcore medical evidence or psychiatric evidence into the record of those hearings. But that requires you to have another workup of your client, right? And you know how hard that is. I mean, it's not that hard to get an order from a court to have a psychiatric assessment done, or a competency evaluation, those kinds of things. But when you start getting into second and third requests, then, you know, the judges are a lot less inclined to just let you keep, you know, running these races over and over and over again, because it takes manpower. The prison, you know, normally the jail staff, but in this case, the prison staff, they're not super compliant anymore because we gave you a chance to have him assessed. So you got to get access for people to assess your client, and then you put that evidence on. But that doesn't happen with a phone call. Like, you know, Dr. Westcott had to, you know, this stuff has to be scheduled well in advance. She's got to get her team up there. There's, you know, I think they were up there for 2 days, maybe at one point. And so that's just more challenging than what the layperson might think it is.
It sure is.
Now, if it were at a county jail across the street where I go, you know,
still challenging, but
a hell of a lot easier.
Right. Now, in retrospect, looking back to the state, all of a sudden, at least what appeared to me, okay, because obviously I don't know everything that was going on at the time, so you'll have to let us know. But in retrospect, is the timing suspicious of the state all of a sudden pushing real hard to get his medical records, when in theory they should not know that those medical records contain something this incriminating?
I don't think that the timing was suspicious. You know, we were in a bit of a conundrum because you have these. So the initial statements were, you know, that he made were over the phone to his, you know, to his wife, right?
Right.
And so those aren't protected by the doctor-patient privilege. They're basic communications, you know, from inside of the facility to out. And so if you're going to explain or try to, you know, explain to a jury why that might happen, then you're putting his mental state at issue. And so by doing that, essentially, we were making the psychiatric records, we were causing them to be relevant.
Right.
And so, you know, and I'm not one of those guys who's looking to have my cake and eat it too. If the law doesn't permit that in any, you know, form, in any manner of litigation, or any arena of litigation, I'm just not that kind of a lawyer. I'm willing to, you know, have a fair fight. And I think, you know, we had to put his mental state at issue, which meant the disclosure of those records.
But I thought that they were looking for them, that they were petitioning for records before you had even put it at issue, but maybe that's just not the case.
Yeah, I don't think that's true. I don't think that's true. I think a lot of this was happening. I think that, you know, there were conversations with from both sides and together with the court that, hey, you know, this is what's likely to happen if we open this can of worms, kind of thing, on his mental health. But I mean, there really was no other, really no other way to do it. Plus, if your client's saying things like that, you know, don't make any sense, they're not consistent with what you know to be, you know, the hard and true facts about the crime scene, things like that, then it's like, wait a minute, I want to know why. Like, what the hell's going on? And the best place to look, at least in my opinion, was to go to the psychiatric records from the prison. I mean, nobody else had contact with them, so where else could I look?
Right.
And so, you know, there was a reason to want to see those records. And then, you know, it just got to the point where I think that in order for us to tell the story about, you know, about how we got to where we are, we really need to disclose them. So I'm not all up in arms over that. You know, I'm not claiming any conspiracy theories here.
Okay. All right.
So as far as Walla goes, though, speaking of conspiracy theories, and
here we go.
I'm not inclined to be a big conspiracy theory guy either. I find them difficult to believe because it really requires a lot of people to keep a secret, which I find is near impossible. People just can't keep their mouths shut. So typically I tend to poo-poo them. But as far as Walla goes, I mean, when you first deposed her, you know, what were you hoping to get from her? At that point, had you read what I consider to be the most damning confession?
Yeah, I had read what I think was the bulk of these incriminating statements, and I had them indexed and, you know, organized. And I actually, before I took her deposition, I actually sent her a very large packet of documents, emailed to her a large packet of documents. They were mostly her reports and some reports from Martin and maybe some other mental health providers. And I basically said, look, I think I'd probably forward them through the prosecutor. Actually, I think I'd forward them through Wexford or up to now, whoever Centurion's attorney.
Yeah.
And I basically said, look, you need to look at these because I'm going to be asking you about these in this order. And so, you know, going into the deposition, she had a chance to be fully informed and prepared because I basically handed her the playbook, if you will. I think that's prudent lawyering. You know, I think it also saves time and money. And it's just, you know, that's the way you do business if you do it right in our industry. And, you know, I wasn't sure what I was going to get. In the back of my mind, having been through this, you know, been in this system for a long time, worked in prisons, I was kind of
Not
I was
expecting much.
thinking, you know, I'm going to get somebody who is probably not the most, it's not going to look the most professional, not going to look like a doctor or a psychiatrist or a psychologist, someone who probably doesn't have a ton of experience in the private industry, somebody who's, you know, probably fairly well committed to the DOC in terms of, an income stream. And I'm trying to be respectful, but when you work in these places, you just know you're not getting the highest quality physicians, because anybody that is a high quality physician can make 5 times as much money working out in the private world, right? I mean,
Right.
that's just the nature of the beast.
Right.
And so I kind of knew I thought I knew what I was going to get, but what I got was something that was way beyond my wildest dreams in terms of, I don't want to use the word incompetence, but that's not far off. It's not an inaccurate word. And I look, I don't have any personal beef with Dr. Walla. I'm not here to grind an axe with her. She's a human, and she's got to make a living. She's got an education. She's got to make a living like the rest of us. But come on, I mean, you got to hold people accountable in this business. And when people are playing with other people's lives, it's our jobs to hold people accountable. And when I realized what was going on, that was my goal, was because I knew by holding her accountable that it was going to improve my guy's chances of an acquittal. I mean,
and for those that don't know, can you expound on what was going on?
Yeah, sure. Well, I mean, first of all, you've got, in my opinion, a doctor, and it's hard for me to call her a doctor. And again, I'm not taking a personal shot at her. I'm just saying, like, there's a certain, professional level that, psychiatrists and psychologists function at in the private world. It's just not even, it's just eons beyond what was going on here. But, this is a woman who, from a maturity standpoint, just was not in a place mentally where she was equipped to deal with inmates. Frankly, and you folks know, some of the most difficult humans on the planet are incarcerated because they don't have anything to do but sit around and learn how to manipulate people and how to get what they want. And I'm not, that's just what you do when you're in prison. Right. And for her, at her maturity level, to be asked to do that was just, I mean, somebody dropped the ball on that. But with Rick, this deep personal investment she had in the case, it really made my stomach hurt.
And we talk about deep personal investment, you mean listening to podcasts and investigating on her own and going to the crime scene, those kinds of things?
Yeah, she knew more about the case, and I'm embarrassed to say this, but she probably knew more about the case than I did in some respects, at least in terms of what was going on in social media. And
how were you able to ferret that out? Did that come out at the dep?
Yeah. Well, I took 2 depositions. It was a 2-part deposition. The first day took about 6 or 7 hours, I think, maybe 5, 6 hours. It was a long deposition, and then I recessed, and then I thought I was done, but then when we finished, shortly thereafter, my phone was blowing up, and all of a sudden, I've got all of this information about her being out on social media and making recommendations about where to, what podcasts to watch. I think maybe she even mentioned yours. I can't remember. I'm pretty sure she did.
She did.
And so that all kind of blew up literally as I was finishing the deposition. I might have even got some of those texts while I was deposing her. So then when we reconvened a couple of weeks or a month later or whatever it was, a couple of weeks later, it was supposed to be the state's turn to depose her. Stacy was going to depose her. And of course, I had a whole bunch of ammo at that new ammo. I'd reloaded the gun really,
right?
Because I had all this information that I had acquired. So here we go for round 2. And, it took a few more hours, if I recall, the second time around. So
do you recall whether she was resistant at first, surprised that you knew this? Like, I'm just imagining it being like a bombshell went off in there when all of a sudden you're calling her out on this. But how did it play out?
No, I felt like she was almost complacent to all of that. Like, it was a weird vibe. And what I mean by that is that it almost seemed like she had an infatuation for Rick and she was enjoying the attention
and the involvement.
Yeah. Like,
which is
the attention I was giving her too.
Right.
Like she was not ashamed of any of this, and it almost seemed like she liked it. And again, if you deal with professionals like I do on a daily basis, and you deal with a doctor who's really got their shit together, and who's a real true professional and follows the ethical standards, there's very little personal communications or any kind of context between the doctor and the patient. It's always very businesslike, and this was not that.
Right. And
It's just bizarre.
the fact that she seemingly didn't even realize the level of inappropriateness of her conduct speaks to that maturity level and professionalism level that you were mentioning earlier.
Yeah, I would agree. I think that's a very accurate statement. I mean, when you're sitting there questioning someone and you're expecting to get these reactions because you're like, what the hell were you doing at the trail? Like, oh, I've just, my boyfriend and I was coming back from Indianapolis and we just thought we'd stop in and check it out. And I mean, I'm like, you can tell from her reactions, like she just didn't see the forest for the trees. Maybe that's a pretty good way of putting it. Like, and I don't think she realized the scope of what was unfolding. And I'm not trying to be grand about this. I'm just like, look, you're going to be exposed in public soon. And I don't know that she realized that because she doesn't have any experience in this arena like Dr. Westcott does. She's been deposed before. She's been in a courtroom. She's seen lawyers work. She's been exposed to lawyers, good lawyers. And you understand how to function in those environments. And Dr. Walla just was not equipped, which is part of her job.
Right. Yeah. I mean, I guess the way I'd kind of categorize it would be she was just tone deaf in terms of having any kind of understanding of what was going on in that moment with respect to just her ethical obligations to her patient. And when you're kind of like going through these questions where you're like, so you're pretty heavily invested in this case. Yeah. And she's just like, oh yeah. It's like just having no awareness of that is so scary to me. Right. It's beyond telling. It's a terrifying prospect because look, I'm in the same place you are. I didn't have the opportunity to depose her. You did. But from an outsider looking in, I'm left wondering, how do I trust anything that this woman has said with respect to what she's claiming that Rick Allen has told her? And to make it even worse, she's destroyed all of her handwritten notes. So, you can't even go back and check her work.
No.
And I just thought that Westcott was so powerful, which again, in terms of her kind of talking about how a narrative in which the most damning of the statements was written in that narrative format with a beginning, a middle, and an end, that's just not how psychiatrists or psychologists take notes from their
or
patient.
how Richard Allen was communicating at that present time, if I'm understanding correctly.
Well, if you saw the jail slips that he wrote to the warden, and I think one was to the not the pastor, but the chaplain, even those didn't have a logical sequence to them. But yet what Walla was reporting was storybook fashion. I mean, it was like Charlotte's Web work,
That's the kind of detail to us as lawyers, it blows the whole thing up. You're like, this is it. People should logically see this makes zero sense. And it's shocking sometimes how that doesn't translate into the jurors,
Well, maybe
when I heard the words,
maybe it did. We don't really know. It sounds like it might have penetrated a few of them. But I thought, Dr. Westcott, the minute I started working with her, and she came pretty highly recommended. I was leaning on some people that I really trusted that are high quality lawyers, and I got what I thought I was getting with her. I guess at the end of the day with Dr. Walla, again, I don't have any personal feelings about any of this with her. There were times, and I really mean this, it would have been the pretrial hearing we had when I called her the first time. By the time we were done, I was feeling sorry for her because I was like, I pretty much knew when she walked out of there, she wasn't going to have a job.
Yeah.
And I didn't want to be the one to have to facilitate that. But look, you're sitting there and your client's sitting next to you and his life is hanging in the balance. and you've got, you know, I mean, I don't know, Daffy Duck or whatever you want to, I mean, whatever you want to call her. Again, I don't mean that person. I'm just saying, like, that's the way I viewed her as a psychologist.
She was oblivious.
It was a
I
joke.
was sitting
It
there.
was a total joke.
It was unbelievable. And like that hearing you're talking about, you started in real night. It was really a tale of two cities, because you started in, it was kind of a, yeah, you had some camaraderie. You're like, oh, you know, these are, you know, this is kind of like how you got your career started. And you kind of, and then when you had to start hammering her, which I think there was a break. And then when we came back from the break, you had to dig into her. And man, it was like she was just oblivious to what was going on. I remember saying to whoever I was sitting next to, I'm like, she's not going to have a job tomorrow. I'm like, she's done. I'm like, what Brad just exposed was like unbelievable.
You know, you hate to be on the brunt end of that, you know, club, because I mean, you know, people got to eat and people have to pay their mortgages. I mean, like, I know people don't want to hear me have sympathy for humans, but I do. But, you know, again, when you got a guy's life hanging in the balance and you've got two victims who've been brutally murdered and their families need closure, you know, I mean, this is what we do for a living, and it was fair to take her to task. I don't think that I was too hard on her. You know, I've gone back and evaluated those things, reevaluated them, and I think that I would probably handle that a very similar way if I did it again.
I thought every question you asked her was fair. You know what I mean? They required answers. Like you said, I mean, the bottom line is she's playing with a man whose life quite literally is on the line. And she had zero ability to understand that. It was to me, it was breathtaking. I sat there throughout those, and like every time she was on the stand, just dumbfounded. I'm like, holy shit, man. I'm like, this is unbelievable. I mean, she cannot be around patients.
I think at one point I
don't want to say it, but I'll say it. She should not be licensed. So she has no idea what her ethical obligations to her patients are. It was unbelievable. And you see, because Brad, like you and I both know that whatever she wrote down in terms of lying in wait, that phrase will forever be seared in my mind. If you think that Rick Allen used the term lying in wait, I've got a bridge in Brooklyn to sell you, and it's a beaut. You know, so it's just, I thought you handled it exactly how it had to be handled. And you're more apologetic than I think you need to be with respect to you doing your job and trying to kind of uncover the truth in that thing. So, you know,
at one point I remember asking her, I'm not sure if I'll get this exactly right, but you know, it was a 6-hour deposition the first day. I remember asking her about, you know, what kind of tools were you using to treat him? What kind of mechanisms were you using to evaluate him? You know, what really is the therapeutic process here when you're providing individual therapy to an inmate in a situation like this? She says, well, I gave him some crayons and, you know, and some coloring pencils. I mean, literally, that's what she told me. And I remember just thinking to myself, you know, it's almost like you can't ask a question. You're just sitting there, you're like, crayons? You know, like, is this a movie? What the hell is going on? That's what she told me, you know? I'm like, pixie sticks? What the hell are we playing with at the prison? What are we doing therapy with? This is crazy.
It was like everything about it was crazy. Like as you developed kind of that entire factual pattern of what was going on in there, it was like, I had never heard anything like it. It was insane. And
remember the patient privilege statute in Indiana says that those communications are privileged unless the communications pertain to a homicide. That's what it says. And so you have a physician who's personally invested in this case. There's not one person on the planet that would suggest that it doesn't involve a homicide. And, you know, she's talking to him like he's her best friend, knowing that all of this stuff is not privileged, but yet never said a word to him about any of this. You know, she never had him sign a waiver or anything.
Right. I mean, it seems like it rises the level of like that was her intent to make him feel this false sense of security, um, and either use it to manipulate. Who knows what went down there? But I know Bob, given all the things that you learned about Richard Allen's mental state at that time, and I know it was something, Bob, you had yourself wondered if they ever considered challenging his competency.
Yeah, those conversations occurred. But again, by the time that we, but once we got some intervention and we really started figuring out what was going on in there, April, May, June of 2023, there was a time period where we saw some improvements in Rick because we were going up and visiting him. And, once we started seeing some improvements, we kept thinking to ourselves, we're going to get him out of here shortly because we really believe that, even though now looking back, we were fools. We just, you want to believe that, you can use your law degree to, change something,
Right.
to change the circumstances in this case. And so we kept thinking, well, we're pretty close to getting him out of here, and he'll improve, dramatically once we do. And then the fight, just lingered on, but he did get better over time. So there really was not a competency problem. Yeah.
Okay. And I think we did touch on this some last time we spoke to you about the guards and the Odin patches, but is that something you've ever encountered before? It's nothing I knew was going on, and it shocked me. How did that, as far as learning it existed, to having them removed, to the guy getting a tattoo on his face, is any of that anything you experienced, and how did that all go down?
Yeah, so the answer is no, I've never experienced that before. And again, I do have some history of I worked in the prison system for a brief period of time, and I also, as you know, spend a lot of time in prisons, just like you guys do. And I had never seen anything like that before. I knew right away when Andy pointed out the patches that, that this was an unusual circumstance, and that there was definitely, I knew that there were definitely dress code violations, if you want to call them that. So I got the uniform policy. Of course, I dug that up, which wasn't easy to find. And naturally, what you find in there is that not only are these things not permitted, they're prohibited. And then I think as time went on and I started to learn more about Warden Gallipo, and really, I told you I took those depositions up in LaPorte that one day. Once I started kind of meeting these people and really talking to them, then it became very apparent to me that we were dealing with one of two things. Either a circumstance where the inmates were running the asylum, and I'm talking about the staff over the administration, and two, where there was just a complete, negligence as far as the administrative oversight. It may be recklessness in terms of what was going on. Then we later found out, of course, that Gallipo, got fired for ghost employment, basically, when he got demoted to the girls' school up on Port. Then he ultimately got fired for ghost employment. So now in my mind, I'm thinking, most likely he wasn't even there. Right. He wasn't paying any attention to anything that was going on in that facility.
Right.
All these people that the state claims that he was visiting our guy in the cell. He was walking and doing rounds once a day and all that bullshit. It's like he wasn't even there.
Right.
And he ended up getting canned for it, really.
So how long from they're informed that these Odin patches exist to them getting removed to the guy getting the face tattoo? And was there any further discussion about that? And how is that an appropriate for a correction officer to have, especially when it was basically like a child having a tantrum? Like, okay, you won't let me wear a patch, I'm going to tattoo my face. You can't do anything about it.
Well, they claimed that their explanation was that they had received these new flak jackets or whatever. They're kind of bulletproof vest type stuff that they were wearing, and that they were putting these patches on these new vests and that the uniform policy didn't apply to the new vest. That was a new, they were going to develop a vest policy, right?
Right.
It's just, I mean, again, you're taking depositions and you're like, it's just two girls got murdered in this case, and we got a guy accused of this, and we're all just trying to, be professionals. And then they come in and start playing these goddamn reindeer games about, dress code policies. And it really pisses you off when you're sitting there, actually taking the depos. Like, really? Like, we're going to sit here and try to distinguish between a patch on a vest and a patch on your regular uniform right underneath it. So that was their explanation. And at the end of the day, they really didn't have one. And so that, we saw those patches, I'm just going to say in January, February of 2023, if I recall. And then by the time we were kind of exposing that and things started changing, it was probably into the summer of 2023. But I think a lot of it was just the administration wasn't paying any attention to what these people were doing.
And when the guy got the tattoo on his face, was that like a discussion? Did anyone ever, like, what was done or said about that?
Yeah, I don't recall, Allie. I really don't recall. I recall the fact, but I don't really recall too much about the details with that. It seems like I deposed him. I'm not even sure which guard it was as I'm sitting here. But it seems like I deposed him, and he said that he had gotten that tattoo between the time that we kind of outed them and the time I took the deposition. So now we're later in 23, kind of into the second half of 2023. And, they just doubled down. Hey, we follow the Norse pagan belief system. That's all this stuff is. We're not Odinists. And I'm like, you've got Odin tattooed on 7 places on your, observable body.
And that would be
by
Randy
definition,
Jones.
are you an Odinist? I mean, what the hell are you?
I'm assuming that was Randy Jones, courtesy of Sleuthy.
Yeah, I think it was Jones. And I will tell you this about him. Once I deposed him, I felt like he was definitely more honest than his partner. But the thing that was unique about Jones was, he acknowledged to me that he suffered from PTSD. And he worked in a prison down south in Alabama, I believe, or Georgia. And it was such a bad, terrible place to work that he acquired PTSD and ended up either quitting or getting terminated because of attendance or something. And he took like a handful of years off from the prison system because of his psychiatric condition. He works in one of these places. Can you imagine what it's like to be detained in one of these places?
Yeah.
And of course we couldn't talk to the jury about any of that. Couldn't help educate the jury that even the guards suffer from PTSD from working these places. And they don't even really have hardly any contact with the inmates, right? Because they're maximum security lockdown units.
Is there a reason to believe, because you said there's like 24-hour, surveillance of him, but how hard would it have been for the guards if they wanted to communicate and find a way to communicate without a camera there? That doesn't seem like it would be impossible. You take him out of the cell and you don't have the camera set up right away. I mean, does it seem like that would be easy enough if they wanted to do it?
Yeah, I think it would be very simple to do. I mean, there are not a lot of people manning these units, especially on the midnight shift when the administration's not there. So you've got, just a, select number of employees, and, there might be one person working in the pod that's, a confined location where you're kind of overseeing everybody else. It's almost like, kind of like if you think of it like a pizza, the pod's in the middle. I know that you two know what I'm talking about, but there's like an elevated pod in the middle, and then you're kind of looking out into the pizza, and those are different blocks that you're looking into. And the people the guards that are working in those specific blocks are pretty isolated. They're working alone often. And yeah, they can certainly communicate with the inmates, but even more so that these jailhouse inmate companions, that they're posting at the door. And, I deposed, I think I deposed a couple of them, and I know I deposed a few of them, and I had some statements from others. Like, they're preaching forgiveness to him and the word of the Lord and all of their, personal agendas while they're sitting there with him because they have nothing else to do.
Right.
So you don't know what the hell they're talking to him about.
Right. And that is something that would never be allowed in a jail where if it was, officers, because even there's been old Supreme Court case law that, talking about God and forgiveness and things like that can literally prompt um, an involuntary, statement or, be considered interrogation, even though, you're not technically asking questions. Like, what you're doing, what you're doing. And they're just doing it through companions who aren't really there to be companions. It's
a powerful message to use against somebody who's isolated from the rest of the world. And we all know that one of the things that most inmates who are detained in really secure facilities turn to is the Bible, because it's the only thing they have. And I don't, I'm a God-fearing Christian and, all that. And I have a great deal of respect for people that really do turn to Christianity or whatever religion it is when they're in prison. But that's the only outlet you have. And then you post an individual up on somebody's cell, and then you have not only the text sitting there weighing on them, then you've got somebody that's, got access to them that starts pushing their agendas. I, in my life, have never heard of an inmate companion program. Now, if you have, great.
I haven't.
It's bizarre to me, the idea that you would let some of the most, dangerous felons on the planet sit and babysit a guy, or I should say babysit a man who's never been in a jail cell in 50, years of his life. And you basically assign a babysitter to him who's a 5-time convicted felon who could be accused of and convicted of all kinds of crimes of dishonesty and violence. It's just bizarre to me.
Bizarre. And, and I'm learning again from Sleuthy that this Randy Jones, the officer with the PTSD from a previous prison, that he's the one who became the acting supervisor of Rick's pod or a pod in early March of 2023. And then Rick suddenly started making incriminating statements.
Yeah. I think he was like the OIC officer in charge when he was during his shift. We can use minced terms about supervisors and all that stuff, but I think that's what they referred to him, how he referred to himself, but I could be wrong.
And I know I'm monopolizing this, Bob, so I'll ask one more and then I'll hand it back over to you to switch gears.
All good.
You handled the cross of Jason Page, who was a crime scene investigator who took photographs at the crime scene. One of the questions that you asked him about was he aware of anyone else taking photos? And my question is, were there crime scene photos that were circulating in the public that were not part of the discovery, the official discovery in the case? And have you heard anything about a crime scene photo taken at night? Does that ring any bells to you?
Well, I am of the belief that there were crime scene photos that were circulated. That was discovered in the first deposition that either I or Andy took of Detective Holman. That was part of that discussion. So I am aware that they had some, what I would call, I hate the word leaks, by the way. It's just a word that doesn't sit well in my stomach anymore. But, you could suggest that there was a breach of integrity with the crime scene early on in the case, in the first, in the early hours or days after the girls were discovered. And they did address that. I don't know that, they could have possibly had any confidence that they secured all those photos, but I think that, that did occur.
Okay. So
what was the second part of your question?
Whether some of those, because that's what I was trying to get at, whether someone other than police officers took actual photographs of the crime scene. Yeah. And I think that some of those might have been night pictures. So
I don't know about night photos. I was offered up a few kind of bizarre photos of what I guess I would consider photos that were taken in the dark of the girls, but there was nothing there that I really believed had any authenticity to it.
Okay.
And that was not stuff that we got from the state. It was just stuff that, we got from third parties that were trying to push stuff on us. And that was okay. I mean, you're always kind of filtering, but nothing I thought had any credibility to it.
So as far as the trial, and this is kind of a broad question, but if you can recall, what, if anything, surprised you guys at trial? Like, what did they drop on you guys? Or you're like, it always happens in every trial where the state drops something. And you're like, wow, man, we were not aware of that. Start shuffling through your papers. You're like, wait, where did they get this? I mean, can you recollect what, if anything, caught you guys by surprise?
Or was new stuff that was never disclosed before, is specifically what Bob's referring to.
Not really. Not really. I don't think that there was anything that, that really blindsided us. I think that I do remember, and I'm just kind of cherry picking in my brain here, but I do remember being a bit maybe more concerned about them trying to connect the bridge guy's voice in the 43-second video with Richard, bringing Harshman up, and Harshman saying, I've listened to that video 50 times and that's his voice, that kind of thing. I mean, I think that we were maybe concerned at one point that they were really inching closer to that.
I thought that they inched right on top of that,
without saying it.
And I don't know if arguments took place in chambers, before court, after court, but to me, the obvious argument, and maybe it's something that you addressed in cross, you're talking about an audio file that has been edited to the nth degree. How in the hell are you even sure that the sound is the sound of Bridge Guy? It is similar. How similar to Bridge Guy is it with all of the editing? Was that something that you guys leaned into?
It was not. I think we could have done a better job of that. Of really kind of digging into the second layer of what was going on there from a technological standpoint. I'm speaking for myself maybe more than I am Andy and Jennifer.
Right.
But I don't feel like I ever was really concerned about that, because I knew from taking depositions that there had been hundreds of people call in or offer up, hey, this is so-and-so, it's my neighbor, it's my sister and brother or whatever. You know what I mean? I knew that was part of the investigation that was undeniable and was just, nobody was disputing that. And so it was kind of, maybe it was negligence in a way for me to just assume that there was no way they were going to be able to connect a witness with that, use a witness to connect those two dots. And right. But you're right, they kind of did. And I mean, I guess in hindsight, that kind of surprised us. And I think that's why I brought it up earlier.
Yeah, I thought
Harshman, didn't I?
Yeah, you did.
Harshman about all these other reports that they had, and I probably could have developed that better, but I wasn't quite ready for that.
I thought McClellan asked the question. Are you saying that is Richard Allen's voice? And I thought he said yes.
Well,
I thought he went all the way, man. I thought he asked that question because I was stunned sitting in the courtroom that she allowed it. Because on cross, you asked him, well, do you have any training in voice analysis? What level of training do you have in that? Do you have any training? He's like, no. You attacked it the only way you could attack it based on the fact that she allowed it in, because you objected.
I was almost expecting your, I don't know his name, if he's an associate or a paralegal, but Max, who also listened to hours and hours to be able to give the competing, opinion. But at the end of the day, my whole thought of it was, how could she let that in when it is admittedly edited and on top of edited, so there's no way to know what changes that makes to the voice itself and how much it sounds like the person who actually spoke words.
Well, I agree with you. I think that's the reason why it came in, is because we didn't challenge that. That's why it came in. And I'm thinking here through the rules of evidence that, the opinion evidence rule in Indiana is really broad.
Yep.
And
They let people they do it in
Oh.
I think almost all states. It's someone who is familiar with their voice and can even get familiar for the purposes of litigation.
Yeah, it's a very easy mountain to climb to get something like that in. But in fairness, I think we could have challenged that and probably would in hindsight if there.
And then I was surprised, and I know you don't want to talk about the motion, but it was a question that when we were thinking of questions last week, obviously was the box cutter testimony from Dr. Kaur. So I was like, wait a minute, that's the very first time that he spoke those words? Is that what the state was trying to tell everybody?
Yeah, the truth is that's the first time he spoke those words. And that's not something that I think was really objectionable on any legal basis. It was just a credibility issue, unless I'm
surprise testimony on. I mean, no.
Well, we don't have. Yeah, but we don't have that rule here in Indiana. That we're a deposition state, and so you're entitled to ask those questions, and you have adequate impeachment evidence if they start making up shit when they're on the stand.
If a witness tells the prosecution something, presumably, like if we don't all just pretend the prosecution was also surprised and didn't know he was going to say that, if he admitted, oh yes, he told me this last week, under your discovery rules, they don't have to tell you that?
Yeah, I mean, I think it's arguable that they would have had to disclose that, but it's not exculpatory evidence.
In my mind, it is. In light of your motion today, and we won't go into it too deeply because I know you can't talk about it, but I'll just give my opinion of it, is just that it is exculpatory because it's helpful, given that a third party confessed to unaliving the girls with that very same device. So to me, that is what makes it exculpatory.
I don't disagree with you, but I'm not aware of any obligation that they would have to offer that up under those circumstances. But again, we can disagree.
I guess the difference we don't have depositions here. So if any witness says anything to the prosecution, they've got to tell it to us, especially something that they're going to testify about, a change in their testimony.
Well, I think if you have, it's different for somebody who's providing, like a psychiatrist who comes in and provides an opinion about something, and this guy's an expert, right?
Right.
And so, but I don't know that when you have testimony that's just what I would call fact-based testimony, where he's just testifying that he has an opinion about what type of an instrument could have, not did, but could have. I think the rules are pretty loose. When you take depositions, if you do them the right way, one of the last things you ask in a deposition is, if you change your opinion about any of this, would you be, so kind as to report that, doctor? And I don't know if I did that with him. I like to think I'm pretty good at doing those things. And
you did.
So you use that on cross-examination as another bullet. But I understand you and I are talking about two different things. You're talking about exclusionary rules, and I'm talking about how to effectively cross a human when you're surprised. But those are some things that we'd think through. I don't know. I'm not sure that you're not wrong, but I'm not sure that that we have a rule that points directly toward that.
Yeah, and I mean, you addressed it on cross. I mean, you asked him flat out. I'm like, well, it would have been prudent after you had come up with this epiphany at your workbench about the blades that you may have made an amendment to your report or something of that nature, that you would have, acknowledged that you had kind of changed your theory in terms of it being potentially two weapons to maybe it was just one, and now it's the handle of the box cutter that left that weird, strange pattern. So I mean, you definitely addressed it
I remember talking to him about the fact that he had. I recall that, but I think the more important part of that was establishing that he had met with the prosecution or communicated with them 2 or 3 times between the time I deposed him and the time that he testified. And I think I remember that might have been the last question I asked. And I remember sitting there in my brain thinking, don't ever ask a question you don't know the answer to, but I didn't have any choice. there. You know what I mean?
Yep.
Sometimes you.
And he said yes. He said he had talked to him, I think, 2 or 3 times.
I actually just read that because I was reading Bob's notes of people that you did the cross and the direct of in preparation, and that is what he said. You asked him that, and he said 2 or 3 times he had spoken to the prosecution. And just to circle back, because I think some of our listeners still have questions and clarification about the breach of the crime scene and photographs that were taken by members of the public. That's what occurred, to your understanding, right?
Yeah, my recollection is that, of course, there was a search party out there, and that there may have been some photographs taken that were breached by people that were non-law enforcement affiliated.
And was that something that you raised in court at
But
some point?
I don't know the names of the people. I never did know the names of them. I'm not sure that anybody was able to identify them. I'm not trying to, I guess I'm just trying to be transparent here. I don't know that it was Bob Smith that lived down on, on Water Street or anything. It was just there was a breach, and they claim they handled it. Of course, at that time, I didn't have any idea there were vans running around and that was going to be a big part of all this, and just the integrity issues with the investigation. At that early stage, we were not really, we weren't running down that trail. So those things didn't seem as big of a deal to me at that point.
Right. And was it something eventually raised in court that there were photographs, that a photograph made its way into court that was not produced during discovery? And if you can't recall, don't worry about it.
Yeah, I don't recall that being the case. I might be confusing some of the pretrial hearings and some things that were offered up. So I don't recall. I don't know.
Yeah, you had the one circumstance wherein, where they were trying to make the comparisons with the leaked photos, where there were circles or
that's what I was thinking, Bob. Thank you.
That's the one you're thinking of.
They offered up a stack of documents, and 1 or 2 of those were not documents that we had ever had our hands on.
Right.
That they claimed Westerman took.
Exactly.
Right. You guys leaked what you never touched.
Mm-hmm.
Right.
So I remember looking at those. I was on the witness stand.
You were.
Yeah, I remember that now. I was on the witness stand. I'm like, these are not photos we've ever been.
Right. You're like, I've never seen these photos.
Yeah.
Before. And we never use those symbols. That's not something I've ever seen before. Those didn't come out of our office.
No.
So, all right, I'm going to switch it up a little bit. Talk about the bullet.
Wait, before you go to the bullet, I had a couple other questions on this same vein about what else can you tell us about either false narratives put out or facilitated by the state or state actors, or leaks that were flowing through state actors?
Well, I mean, that's kind of a broad question, and that's an Andy Baldwin question, really, honestly. But there were 2 things that stood out in my mind, I guess, from a leak standpoint that I dealt with that were bothersome. One of them had to do with a YouTube bit that I want to say, and I don't know if it's okay to name other people.
Sure. Yeah.
I want to say maybe it was Gray Hughes. There was a YouTube bit from him, and it had to do with, oh my gosh, seems like it had something to do with maybe some of the incriminating statements that he might have mentioned. Oh God, I'm struggling.
I think there was a time that he mentioned you guys are going to see something about, if this is what you're referring to, that he mentioned, expect to see something about that van coming back.
Right.
Yeah. It was the van. You're right.
And it was before.
It was well before we had any information about any of that. Yeah.
Right.
I remember watching the YouTube special, and it was maybe a 8-minute bit or something. It wasn't a really long bit, but so that was one of the pieces of information that I knew did not come from us. And clearly somebody knew about this or was leaking this information. The second one I've already forgotten now that we were talking about that.
Well, and I know one that Andy told us about was that podcasters reached out to directly to Richard Allen, and this shocked me, and asked him about his attempt. about his wife, number one. That one I did know. That had to have somehow the state conveyed. But Andy said they also asked him about him trying to enter a plea and claiming that his lawyers didn't let him before you guys even knew that that was ever said.
Yeah. Some of that stuff was covered in a closed hearing. And I don't think I'm going to talk about that just because it's not really part of the record.
Okay.
I think I'd be kind of careful with that.
Okay.
Yep. Sorry.
And then no, that's perfectly. And then Andy had shared some details about how Holman treated him and tried to get him arrested. Did you experience anything similar, or are you aware of people connected to the defense team or potential defense witnesses being treated similarly?
Yeah, well, there's no doubt that Andy was, he was in the crosshairs, and that the intention was to try and get him arrested, which really does just get in my craw. I mean, I can't explain to you how it must feel to be Andy, and I'm not suggesting Andy's looking for sympathy, but the idea that somehow he was, that they were trying to, cuff him up and haul him away over what at best was negligence, at best. And it wasn't even that. It was just, it was just an unusual circumstance that Westerman put all of us in. But I never really felt like I was in the crosshairs in terms of Holman's pursuit. I was more concerned about how things were going to go down if we were held in contempt. Because because I practice in the civil courts, one of the things as a civil lawyer that you have the ability to do is to force somebody to come into a courtroom with a subpoena, make an allegation that they're in contempt for violating a court order, and then essentially create a scenario where you can ask the judge to put him in jail.
Right.
It's almost, we call it prosecuting pleadings or contempt citations. Like you become the prosecutor in a way, right?
Mm-hmm.
And if you reach your burden, the judge just put people in jail. And that happens in my world, monthly, maybe not quite that often. Every couple months, 5 times a year, I might be involved in something where somebody goes to jail because I accuse them of something. And so I knew the power of the judiciary when it comes to contempt findings and what you can do in Indiana. I think that the maximum time you can serve, I'd have to look it up. It's like 180 days straight time. Like
Wow.
you can get tossed in the clink for, there's no good time credit with contempt findings. And so my point is that I'm more worried about that. I have to come home every night. My kids are all old enough to know, kind of what's going on. I mean, they can see the forest for the trees. And, I think there was a time when at least one of my 3 daughters knew that was a possibility. And I think, at least she, if not maybe a couple of my kids, were pretty worried, like, hey, is dad coming home tomorrow? And again, I'm not looking for any sympathy. I'm just saying, like, it's one thing for us as adults to know that, hey, you know what, judge, martyr me, throw me in jail, right? Like, whatever. Right. I'll spend a couple nights and they're fine, whatever. But when it starts to, that burden is imposed upon your family, that possibility, then things get to be more serious.
Yeah. And what about the Click's arrest and the timing of that? Did you think that was tied to his involvement in this case?
Yeah, I don't have any information either way to make those kinds of allegations. I think that happened like right around the time we were in trial.
Right before trial.
Yeah, I mean, it was very close. And I think my point is that we were just so inundated with work and preparation. There were a couple of things that, that we really just didn't have time to really work through with any depth. And it was that, and then the issue with the prosecutor.
Going through the phone?
No. Who was the third prosecutor? That's terrible. Jim Luttrell.
Oh, right.
Luttrell had this situation with the appellate courts where there was a finding that he was involved in some foul play and some dishonesty. And, those are the kind of things that maybe in a perfect world you'd work through if you had some time.
I was shocked that he was still, I'm like, why is he still on as the prosecutor when he's been found? There are findings by a federal court.
Yeah.
about his.
Certainly we didn't bring the challenge. In fairness, you know, it was not a challenge that we brought, and a lot
But
of
it
it was
could have
just,
been something the bar did on its own, or the prosecutor's office did on its own, or I don't know.
self-imposed kind of stuff. But I'll say this too, and again, I know we got a lot of people out here that have, kind of conspiratorial beliefs about some of this stuff, and that's fine. I think a lot of it warrants that. A lot of this case warrants that. But I had a good working relationship with Jim. I'd never heard anything bad about him from anybody else that knew him or worked with him. Frankly, when I heard that, it was a shock to me that there was anything out there that even hinted at that kind of behavior. And I don't have a personal opinion about it, but I knew that in my dealings with him, he was a straight shooter, so to speak, no pun intended. And I just didn't have any of those experiences with him. So I don't know that we really spent a lot of time
thinking about
working on that or focusing on that, because
we did a whole live on it.
Did you?
Yeah.
And then Bob, I got one
I'm
more
not
question.
saying you're wrong. I'm just saying I'm not going to sit here and talk about things that I'm not really well
Privy
versed
to. Yeah.
No, we appreciate that. And
that's
then Bob, I
fair.
got one more question along these same lines before you move on to the bullet. You handled the cross of Brian Olney, I think. He's another officer with the Indiana State Police. He testified, I think it was on direct, that there weren't any trail cameras found. Was that a surprise? And can you tell us how, like, what was going on? Why you've got some witness saying there's no trail cameras, they're looking for trail cameras, and then you actually find trail cameras that put people around the crime scene at a time where they're claiming there were no people around the crime scene.
Yeah. So I think that was Olahay, who was one of the crime scene techs. And I don't remember that examination necessarily, all because I don't think it, in my mind, wasn't one of the more significant ones that I did. But what I do know is that there were some trail cameras that were in that general area, at least one, if not two. They were examined. There were some photos, but nothing, at least what I recall, of being any real significance. Maybe the absence of anything was more significant than the existence, of any photos. But there were trail cams, yes.
Yeah, well, we know from the motion that was filed today.
Yeah.
So there was a little significance in one of them for sure. So I want to switch gears a little bit to the bullet. I think ultimately, again, like I feel the same way. You can't try to kind of impose what one juror's opinion was as to everything on all the jurors. That's not how it works. But at least from her perspective, despite her terror of you, her absolute terror of you, and your I think you were effective in neutralizing the bullet, at least in her mind. She went on to say, look, I thought Oberg was amazing, but at the end of the day, I just that didn't weigh very heavily in my decision one way or another. So, I mean, you were effective there. One of the criticisms that I've heard, and it wasn't as to you, but it was maybe as to the choice of your expert, your tool mark guy. Like what was the decision in terms of not having him?
Why didn't he do an evaluation?
Yeah. Why didn't he do his own physical evaluation?
Yeah. Well, again, those are strategy decisions, and it has nothing to do. Well, I don't want to say that. It's not fair. It's not entirely driven by the idea that we were afraid that we would learn something that would be detrimental to the client. That's not what drove this particular discussion. I think it was clearly one of those things where once we did our homework, we knew what they had. We had deposed their witnesses, or their witness, Oberg, that is. And, I really was starting to get a feel for the strength of that evidence, or the lack thereof, that there just wasn't the need to take it any further. Those are strategy decisions. And, a lot of people, I assume that you have listeners that, really want us to go out and prove that our guy is innocent. But if that were our burden as defense lawyers, we probably could handle 1 or 2 cases a year, and you wouldn't have time to do anything else. And I understand this was, on the biggest stage and the highest stakes and all that, but there is just a certain aspect of, hey, we're going to do what it takes to neutralize or to destroy, if you want to have a, if you take an aggressive word, the state's key pieces of evidence. And I felt like we were prepared and that we had the goods to do that without having to go and have examinations done. I mean, that's just really the reality of it. Like I wouldn't go to, put any money on a table in Las Vegas over how this ballistic stuff was going to go. But, once the work was done, the groundwork was done, I was feeling pretty good. Like, hey, there's a ton of doubt here.
Yeah. Right.
And I just didn't really feel, I think I was kind of making the calls on all this.
And you made the right call. At least if you take what that one juror said and carry it over.
Yeah.
Because
you might find out that's another juror felt differently. But yeah, I mean, it was comforting to hear that did not carry the day. But again, we're still we're preliminary on that. I mean, we may be jumping the gun on that a little bit, no pun intended.
Maybe not. But to me, kind of go to your point, when you look at her testimony on direct, in terms of what I was looking at, I couldn't believe what I saw in terms of what they tried to introduce as evidence as there being a significant agreement. I sat there and I'm no genius, and I'm certainly no tool mark analyst, but I didn't know what the hell they were talking about. I had no. And then she backs it up with, I don't want you to look at the pictures, telling this to the jury. I don't want, what were they supposed to, it really boiled down to, I saw significant agreement. You're just going to have to trust me.
Yeah, trust me.
That was literally her testimony.
I think by neutral standards that you would have to accept that that's what she was saying. Like, I understand, we all have our own kind of views of this.
It is what she said.
That is what she said. And I wasn't really floored by it because I think I was just in the intensity of the moment, but I was pissed off, that's where we were. Like, we spent all this time and they've had all this time and they have all these resources. And it comes down to, you know what, just trust me about this, hang this guy because you trust me. And it's like, we don't, I mean, who in the hell are you? You don't even work for the state police anymore. You know what I mean?
Yeah, you had your big, beautiful, blown up demonstrative evidences, so you're going to tear her apart. And she's like, I don't even look at the pictures. Forget the pictures.
Just trust me.
But I have these big pictures I want to show you. Yeah.
Maybe that's part of what carried the day to the extent that we were successful, in fairness. We didn't get a lot of detail from the one witness or the one juror about why she felt that way. I do think, I'm going back and being critical about my own work in that circumstance. And I do think maybe I might have been a little overbroad. Like, I probably could have cleaned some of that up and tightened it up a little bit more. But because it was such a unique situation, even for the experts, they were all like, this is something we don't deal with often. This unspent cartridge compared to a spent cartridge. It's just, in their industry, I think they acknowledge that there's maybe a handful of studies that even bothered to compare those two environments.
But she wasn't even able to compare those two environments because she had to spent the casing. She had to fire the gun in order to make similar, what she called similar markings.
But because there was so much, it was all a very new circumstance, even for our expert. Like, this is just unusual. I guess maybe I was maybe a little overbroad about,
Well, I think just because now knowing that their witness is gonna get, if there's a retrial, it seems worth the extra mile for her to look at the damn thing under a microscope, just because their expert's going to claim you can't do it with your eyes. You have to use this. You have to see what I saw in the stethoscope, and I'd be prepared with headphones for all the jurors, so that if they tried to say what's being said on that audio tape, the jurors can. You can't have someone say, you can't hear what I heard because I listened to it with the headphones. Well, then either he can't testify to that, or the jurors have to be given headphones to listen to the audio, because there was a lot more there than what was released to the public initially with kind of 2 splicings of
Yeah,
Down the
sure.
Hill Girls. Wasn't even really the full
Babe, you
set.
said stethoscope. You meant microscope.
Yeah, sorry.
Stethoscope you hear with.
No, I know that. Thanks. I just
So,
Yeah, and, I'm obviously interested in what the other jurors have to say about that. It was one of those pieces of evidence that was, super sexy. It really did prompt his arrest, no doubt.
good.
I think the
Good.
police put way more weight on that one piece of evidence, and I think they learned over time that it wasn't as powerful as what they had believed. And I'm not taking credit for that. I'm just saying, like, I think they didn't know jack shit about it either, and they needed to be educated about it. And that's the world you live in when you're a police officer. You're trained. These guys are trained to rely on these things in the normal course of their day, but they're very rarely criticized or critiqued or vetted when it comes to this kind of technology. It's just lawyers don't, in my normal daily world, lawyers don't scrutinize this kind of evidence very often. When's the last time you were in a courtroom and you saw someone taking a firearms examiner to task? I mean, how many times in your whole professional life have you seen that when you've been sitting in a courtroom as a casual, a bystander?
Pretty rare. It's
Yeah.
pretty rare.
Just doesn't happen.
Right.
So the
Right.
police
But
believe
most
it's
of the
all
times they're
possible.
putting in established science, and things have really changed in recent years too, as far as that not even being an established science in the way we were used to, let alone what they were trying to pull in this case with an
Yeah, now
unmet
it's
case.
DNA and phones, man. Like that's
Yeah,
that's what
phones
you
are
see.
that's the next frontier, digital forensics.
Yep, that's
And
it.
I don't want any part of that. Boring.
All right, so like
By the
I'm a
way, you see where one of your local judges just kind of obviated the Winfield decision, the firearms decision that was handed down. It was Winfield. I can't remember the judge that handed the decision down a few years ago in Cook County that just annihilated the firearms expert in the whole industry. And it was a nice template for a lot of us. But there was a judge the other day that just struck pen to paper and essentially eliminated that. I can't recall what the procedural mechanism was, but
Oh, now
I
I'm
didn't
gonna
see
have to
that.
look at that. He's trying to revive the firearms analysis that was
basically, yeah, I said whoever the judge was that decided the Winfield case was crazy, basically. But that decision is not a seminal decision, I wouldn't say, in the industry because it's a trial court level, decision. But the way that particular judge articulated his view of the firearms industry in writing was a very nice, logical, well thought out ruling. And of course, the anti firearms exam people were pretty happy with that. But there was just something that occurred in the last week or two, I believe, and whoever the new judge is in that courtroom,
Judge Hooks.
Judge Hooks.
Yeah.
Yeah, I think there was some ruling that he or she issued that essentially kind of neutralized that finding.
Hmm.
So just FYI.
Yeah.
Interesting. So I want to ask you about two things, and I know that you guys talked about it on on Lawyer Lee's show, but and I had wanted to ask, in terms of calling Kathy, and I know that's a strategic decision. If there's a remand of this case, do you think? Because I know how I felt in the courtroom. You know what I mean? Like in terms of whether or not you guys should have called her. I mean, like was that a pretty intense discussion whether or not to call her? Like in terms of balancing what she can bring you or if she can hurt you?
No, not really. No, I just didn't. We didn't feel like that there was really much to be gained by that. There wasn't really any challenge by the state as to what his actions were like in the hours after the girls came up missing, the days, hours and days.
It might have
And
been more significant to have mom and sister testify to his normal behavior before leaving to go
yeah,
to the bridge.
that's a valid point. And I mean, those are things we talked about a little bit, but Kathy, to get the answer or to get to your question, Kathy was not really. I mean, I had prepped to call her, and I spent a lot of time doing that. and there was a plan in place, but I think to a certain extent the trial and the presentation of evidence was kind of streamlined as we got into the trial and as we moved through. And I think it was pretty obvious that there were various issues where we were, let me just say, the court was kind of trimming the fat off of our operation.
Right.
Maybe it's a polite way of putting it. That's just the way things were unfolding. And so we had very little latitude in terms of the type of evidence we were able to put, the types of witnesses we were able to put on. I think Dr. Gracian was a good example.
Yeah.
If you recall, he was the expert that that I had worked with on solitary confinement and false confessions.
Right.
And I could have had him up there for 3 or 4 hours if I wanted.
Easily.
Really provided a lot of, very, substantive evidence about how these things unfold. But we just weren't permitted to do that.
Yeah,
so
I wanted him. I wanted him up there longer because like what he was saying was fascinating when he was able to kind of break down how memories are made, and just like that one phrase that, your memories aren't made from when the thing happened. You're remembering when the thing happened.
Mhm.
So
Yeah.
your memory is actually a memory of a memory.
Mhm.
And each time you remember it, it's kind of a new memory. I had that issue where all the witnesses were testifying from a phone recording of an event they were at, but when you watch the phone recording, you could see their back was to the part that's being depicted on the video, but the government was allowed to call them to testify that they observed that happen. And pre-trial, I screamed and yelled and fought, and I'm like, Your Honor, they're testifying about what they saw on the video, not their memory. And she would not let me have my memory expert.
Well, we went through that in this trial. And I think the point is that Kathy, it was one of those things where by the time we got to the end, it was like, there's not much she can add. And we're also going to struggle getting in what we want to get in anyway. The one thing that, and, you two can chime in on this, but the one thing that they teach you in, these trial practice institutes when it comes to, presenting your case in chief is to humanize your client, and in this case, I really, felt like we probably didn't do a very good job of that. We may have done a poor job of it, in fact. And that bothers me. But one of the ways to do that is to call a spouse up and, have her kind of talk about what it's like to live on, what it's like to wake up with Rick on a Saturday morning and what kind of things they did together and, where they went on vacation and the trips to Disney World and, how he was a goofy guy and he liked to, paint his face and, and act like a clown or whatever. And, that's all great when you're in trial practice and it sounds good in theory, but when you get in the middle of these trials and you've got somebody who's kind of really, really cracking the whip on you when it comes to the scope of your evidence, then all of a sudden it becomes much more difficult because what happens is that you put a witness up there,
can't get what you want out,
prepped, and then you can't get a question out of your mouth without an objection. Then the next thing you know, the jury's sitting there looking at you like, okay, you're unprepared. You're trying to pull the wool over our eyes.
Yep.
You're trying to hide something. I mean, they come up with all these other theories about what's going on when in fact it's just me trying to educate you about my client, but I can't do it.
Right.
And so, you end up just scrapping the witness. And so some of that goes on in trial practice.
So one of the things, and it's easier for me to question you about some of this stuff than it was Andy, just because he's so emotional and he takes it so internally and personalizes it.
Yeah.
But I felt one of the powerful things that you guys got in was the photograph of Weber's garage with the sticks.
Yeah.
And I kept saying, if that was me at closing, and I know what your limitations were, that I would have thought, look, these jurors, they're not going to think looking at the crime scene itself is all that important because the judge didn't let you get across how unusual the crime scene was. That I would have thought to say something like, I know this is not something you're going to want to do and it's going to be difficult, but you have to look at that crime scene and you've got to take note of what stands out to you. And, think about what were those sticks that were in.
Yeah, try to marry those two concepts together. Yeah.
Right, but almost like literally prompt them to take time and actually look at the crime scene so that they know, wait, there's something important that I need to look at here. Because sometimes, them figuring it out on their own is even better than you handing it to them,
Yeah,
So,
sure. Yeah.
but if like I know myself, and in we had gruesome photographs where we're defending someone for a child unaliving. I couldn't look at the pictures myself like the whole time. All right, Bob, you look at them.
Mhm.
So I know that they would have been not wanting to look. So I thought that would have been helpful to let them know there's something there that you actually do need to look at, how painful that's going to be. And like you said, sort of marry those together.
Well, but in this case, I mean, in fairness,
To
those crime
yourself.
scene photos were flashed up on a 55-inch TV in front of that jury.
But who knows that they ever that
Well,
it dawned on them that there's something unusual, you know? There's more than meets the eye.
yeah. I mean, I hate to say that I mean, I don't know who could look at those and think that it's not bizarre, but maybe one of those jurors didn't. I mean, I'm not discounting
Right.
what all humans believe, but I mean, if there's one thing about those crime scene photos that jumps out at you immediately, I mean,
Is the similarity of the sticks.
yeah, and I don't know. I guess maybe we overlooked that. The answer, I don't know what your question is, but my thought is this: we did not marry those things together explicitly or expressly, I think is the right word, in closing. But I don't think that was something we intended to do and overlooked. We just didn't intend to do it.
All right, which leads me into which
Again,
is probably
we're walking. Sorry, Bob.
no.
Again, we're skating on really thin ice.
Yep.
In that courtroom for almost 30 days. However 20 days of trial or whatever it was, and you know what that feels like. And I'm not a real renegade lawyer to the extent where I'm, interested
overstep the judge's explicit, pretrial rulings.
Yeah, I mean, like I'm willing to go back in the corner and, I'm willing to go back in the corner with the judge and point at him, from close range and tell him you're wrong. You're wrong. And just because you wear a robe doesn't mean you know more than I do, or you know that you're going to run the show here. We're all part of this, event. But when you're sitting there and you've got pretrial rulings and you've got a judge who already terminated us at one point, there was that, and so with that in mind, we were skating on thin ice, and credit to the prosecutor for putting us in that position.
Yeah,
like from a strategy standpoint. I mean,
Sure.
I recognize this is a lot of strategy involved in these things, and some of it has nothing to do with a van or a bullet or
Truth or justice.
exactly.
Well,
I appreciate that, but the truth is that this goes on in courtrooms all over the
country, all the time.
So I'm not going to act like it doesn't happen, and this is the only case that it ever happened.
And we've been abundantly clear about that with our listeners, at least, saying that this is you're seeing a grander stage, and maybe maybe some it's some compounded types of things, like you've got a little of everything going on, where maybe in your typical case it's like a little of this, a little of that, you're getting it all.
Yeah, everything's enhanced in a situation like this. Yeah,
Right.
Magnified is probably the right word. Yeah.
Yeah, and at the end of the day, I mean, you have to kind of like sit back and when you look at it from the kind of the 10,000-foot view, and you're like, wow, in terms of the strategy that McClelland employed, which and I'm not asking you to say it, so I'm going to say it, but with respect to getting that third party culprit stuff out, I think Gull gave him a real big high sign, like, hey, you might want to file a motion to exclude this stuff.
Yeah, I mean, the timing of it's hard to ignore.
Yeah,
that's me being a professional.
I'm saying it was overt in my eyes. And one thing that I've mentioned that I hope the is mentioned in the appeal is that what I learned from that juror interview is that the juror questionnaires went out before her ruling. So it asked people, have you ever heard of Odinism?
Yeah, sure.
And that compounded the prejudice of her not allowing Odinism, because this went far beyond third party culpability. This went far beyond that. You can't mention the words Odinism. You can't mention it. Limited you guys in being able to attack the investigation itself. And if they followed,
Yeah,
for
well,
example,
it burden shifted, because
really did.
what happened, which you and I know in our industry might be the biggest sin of all, right? If you're an official that's that's officiating one of these things, it burden shifted, because essentially they just stripped you of the ability to point to anybody else. So which means then now you are imposed with the high burden of exonerating your own client, and that's not, you know what I mean? Like, it's
Right.
like, okay, now we got to prove our guy's not guilty, and that's what it did. And I think it is interesting, just from a legal standpoint, that the strategy that was employed and that worked by the state to limit this third party evidence is also most likely, I think, what the appellate courts will sink their teeth into. I believe that. I could be wrong, but I think that that's the number one issue in front of the appellate courts in this case.
I believe it too. And I just believe those juror questionnaires compounded that prejudice. It added to the prejudice, because they were expecting to hear something they didn't hear.
Yeah. Yep. Well, didn't the juror in the transcript mention that she knew there was other information, or did she suggest that she was aware that there were other suspects?
Well, there was a mention of Odinism in the juror questionnaire, because if you'll recall, when you guys went in,
I put that together. Yeah, I remember that.
Right. So, but on the first day of the 3 days of hearings, when you guys argued your third party culprit motion, she let you guys know on that day. She's like, "Oh, the juror questionnaires just went out. We just sent 600 of them out." So, in terms of her sending them out before she had made a ruling on that, knowing that that was going to be in there, and then kind of setting the stage for any juror. And, I mean, look, man, like in Indiana, you got to be living under a rock to not know anything about the Delphi case. I mean, if we're being honest, anybody in their 20s or 30s that listens to podcasts or looks at YouTube, which is, I would argue, probably a vast majority of people, have heard about the case. And it's like,
well, especially when you're sequestered, or I mean, when you're veneering all these jurors, and you're putting them together. They're spending, even before they're selected or impaneled, they're spending time together talking about the case. You know what I mean? They're all sitting in the courtroom. They go to the breaks together. I mean, so there's even an opportunity to talk about this stuff before they're even impaneled.
Well, what do you think about the juror indicating that they were so afraid of Richard Allen, they were scared even being in the same courtroom as him? And as Bob pointed out, that they talked about, there was these discussions about having staring contests, and the look of his eyes, and that they were intentionally looking, and some jurors were not looking away until he looked away. Is that discussions that they're allowed to be having?
You mean during deliberations?
I think
they
were having them during the trial.
I mean, if they're all together, I think the rule is they can talk about the case if they're all together. In fact, they're admonished that every time they break. So probably permitted to talk about those kinds of things. Was that in the transcript from the one juror that we've heard from?
Yeah,
I kind of remember some of that. I remember talking about his eye rolling or his, his eyes, but I don't remember him talking about being scared of him.
Yeah, I think I'm remembering correctly. They said that it was hard to even sit in a courtroom with him. And so maybe I might be using the word scared and they didn't. I'd revisit it, but there was definitely something about that. And there was definitely something about staring contests, that some of the jurors were looking until he didn't look away. And that was something that they were openly discussing. Now, a lot of our listeners have had this question. I did explain earlier today that I don't think it's an issue during deliberations. They talked about how the jurors broke up into 4 groups
I do recall reading that. Yeah.
Do you see any issue with that as long as they come back and talk about it again together?
Yeah, I think if they're confined in the same room, that's permitted. I do think, to the extent that they would empower more than one, oh geez, it's getting late.
Foreman, not foreman.
Foreman, thank you. Empower more than one foreman, that could be problematic because they're instructed to only empower one foreman. But I don't
And
think there's any problem with them breaking up in subgroups as long
Right.
as in a confined room. And
Okay, and
we've
it
seen that
seems
before, right? Like you have the rogue juror or two who go off in the corner by themselves and they really won't communicate, or they're not really willing to work with the rest of the crowd. They're kind of the misfits. So, I mean,
right.
I think that happens in lots of different dynamics and during these jury
And
deliberations.
revisiting what one of our listeners was actually asking was, and maybe there is something to the fact that they split them into groups. If this is accurate, I didn't remember this specific breakdown, but that you've got the groups being 3 with 2 guilty and 1 undecided in each, as though those people needed to be treated differently. And was it more a matter of them putting them into these groups in order to convince the, you know, uh,
Yeah, so there was some premeditation, or there was some manufacturing, I think, that went on with the way they divided the groups up.
right. That's
Yeah.
what's being
I
indicated.
mean, I don't want to speculate on something I don't really know about. We need to talk to more jurors and find out what the hell's going on before we really get into kind of drawing conclusions about that. I don't know.
In Illinois, once we are able to have the contact information for the jurors. I go out and have had private investigators
Yeah, sure.
interview jurors afterwards. Is that not available to you guys?
We always, this is the first case I've ever been involved with where I didn't get the names of the jurors. I mean, we call them by their names. I've never tried a case before where I wasn't calling the juror by their last name, unless I just forgot it, of course. So that was unusual. We don't always get addresses, and phone numbers, things like that. But there's not a problem at all with us, tracking down a juror in the parking lot. I've done this lots of times. I'll walk out of the courthouse and my office is right across the street, and I'll be standing outside talking to somebody, and then a juror comes walking by because they parked down around the corner from my office. And next thing you know, you start having a discussion and you learn a hell of a lot about what just happened in the past 3 days.
We
Yeah.
try that after every jury trial. We try
Always.
and catch them either in the
I've
hall.
run into one in a grocery store before, and I'm like, oh my God, I think I really wanted to talk to you. I can't remember if we got an
We got to not
NG or
guilty in that.
Yeah, right. My
and
brother brought one on a date one time to one of our family outings, and he was like, "You remember me?" And I'm like, "No." She's like, "I was on your jury last year," and I was like, "Oh shit."
I got to pick your brain now.
that's
But,
funny.
I mean, to answer your question, that's the first time I've not been, offered up evidence of the juror's name, at least at a very basic level. That was a little strange to me. But I probably practice in maybe a total of 10 counties on a normal basis. There's 92 counties in Indiana, I think, total. I probably practice in 10 of them kind of regularly.
Right.
And, my sample size when it comes to drawing conclusions about what goes on in the rest of the civilized world in terms of jury practice is not necessarily as expansive as like Andy, for example, who practices from one end of the state to the other.
Right.
So, I don't
And
know.
I know we want to wrap it here, but I think a couple of people have reached out to us about, and I don't know if it's the same case, but the Delphi crime scene being similar to an unsolved 2012 Iowa unalivings in Lyric Cook 10 and Elizabeth Collins 8. So, and someone else reached out to Bob and I, like there was a very similar crime scene. I don't know if it was the same one. We figure you probably get stuff like that all the time, but
Yeah.
there you have it.
Yeah, I'm taking some notes here, but I kind of remembered somebody mentioning the Iowa case in the course of our case, but those are things that we would shove off to Matt Hoffman and let him.
Yeah, I think a
As-
documentary dropped like just probably like 6 months before trial, with a case where they actually mentioned your case with Rick, and at some point, because they ended up solving that case, and it was kind of a very similar crime scene, and that guy turned out to be a serial killer. But it was interesting. I'll figure out what it was, and I'll
that'd
shoot
be
it over to you.
nice. I'd be interested in that. But.
Yeah. All right. Look, man, we've kept you for 2 hours. You are always a gentleman and a scholar. I appreciate you very, very much for hanging with us,
Yeah,
for
sure.
answering all the questions, man. And you know, I mean, I'm sure I'll be talking to you, but you know, I hope at the end of the day that you get to retry this case. I think you guys, I think that you guys have a lot of really strong issues on appeal, and I think, but you never know. I mean, you never know what an appellate court's
Yeah.
going to do, man. But I hope you get the opportunity to do that, and I think
Harmless error. Harmless error. You know, tell all your viewers, if there are two nasty words in our industry when it comes to appeals, it's harmless error. And I think we're always concerned about those. Certainly concerned about it in this case.
But like you said, that's not when you're talking about limiting the entire ability of the defendant to present a defense. That's not a
cut your legs out, man.
Yeah.
Cut your
That's
legs
why
out,
I think the
man.
third party stuff is the most important aspect of the appeal. You know, one of the cool things about this case, to the extent it's cool, I don't know if that's the right word anymore. Nothing's cool about losing, but one of the things that I'm appreciative of is that Mark Lehman got assigned to the appeal. And, you know, Mark advocated for Rick and kind of us, frankly, when this thing went to the Supreme Court.
Did a great job.
Mark's a real good, I mean, we're not best friends, but he's a friend of mine, and his office and my office are just literally a 2-minute walk. And so that's going to be a really nice circumstance because the entire file is basically at my office now. And so Mark has got access to that. And he and I just, you know, we work together a lot in the normal course of business. So I'm really happy about the continuity that'll exist there.
Yeah.
And then I don't know if any of you know Stacey Uliana, but you know, she's one of the most highly respected appellate and trial lawyers that's ever practiced in the state of Indiana.
Yeah. Well, that's who Kara Winicky wanted.
Yeah.
Unequivocally, that's who she wanted. So,
man, you know, we're lucky somehow that's happened. If these two, and I'm not putting pressure on them because I understand, you know, just how difficult it is to maneuver in their arena. But if these two can't figure it out, then it wasn't meant to be. That's the way I feel about it. I mean,
then it's going to post-conviction line.
Well, it's probably going. It's in my mind, worst case scenario, this thing ends up in the federal court system.
Yep.
Where issues like the due process aspect of his detention would be paramount.
A big deal. A big
maybe
deal.
bigger than they will be here in Indiana, in the appellate courts in Indiana. That would get more traction, I think, you know, in a federal setting.
Yeah.
His detention circumstances. So it is weird. This industry is very unpredictable, and it's Mark and Stacey understand the environment that they'll be litigating in and the mentality of those justices. And that is paramount to being successful. Right. And I never imagined any of that when I was in law school. Didn't think that stuff mattered at all.
Very good to hear that that he is in such good hands. So
indeed. Yeah. All right.
Thank you for all your support. I know this is kind of the cheesy ending, but like I haven't had a chance to say that. I mean, I'm just grateful that people are interested and people are interested in fairness. I'm not so interested in people that just have rogue opinions because they hate the cops or because they hate defense lawyers or things like that. I really don't have a lot of time for that in my life, but I do have an interest in people that are, you know, even-minded, you know, that want things to be even-handed and that want fairness and that have open minds and that appreciate, you know, that people are trying to do their jobs to create outcomes that are favorable to whatever side they're on. In this case, it's Richard Allen, and I believe in Richard's innocence. You know, and I'm just grateful that there's a lot of support, and it really does help people like us get through these things. I mentioned my wife before, but man, it's good to have a fan base, you know, when you're playing baseball at Wrigley Field, you know, if you didn't have some fans in the bleachers, it's just not the same. You know what I mean?
100%.
It really helps, and I appreciate that. I'm really grateful for that.
Thanks
Always,
for coming.
man. Always. Thanks, Brad. We appreciate you, brother. Hey,
Anytime.
give hugs to the family for me.
I will.
All right.
Bye-bye.
Take care.
All right, let me just thank some new members. So,
all right, I got to dip out. I'm going to argue with Gray Hughes on Court TV. I love you guys. You guys come check me out. I'm going to go be arguing timelines with him over with Vinny. So handle the thank yous, babe.
All right.
All right.
You better give hugs right now, actually.
Hugs, family hugs. Love
That's
you guys.
for all of you. That's what you're getting.
One family hug for all of y'all. All right. Love you guys.
All right. So thank you, Jay Swoop and Innocent Investigation, Mags, Margaret Kelly Gorbett, January Milliken, Wilco Girl. Nice. M Passenger 33, Shauna King, Asphalt Sally, Professor Kate. Thank you for your generosity, Mudbug. Linda Lane, new member. Ginny Trioli, new member. You guys are true heroes. Love the Defense Bar. Lead with Love, member for 14 months. It is helping Brad. People are waking up in our own communities. And thanks again, Mugbug, for gifting memberships. Indy City, you can't say you might need a lawyer and it be taken seriously, but Richard Allen says I might have. Thank you, Lead with Love. That was very generous. Anne Marie, thank you for your generosity, and we did touch on your question. Mudbug gifted more. Thanks again, Mudbug. Billy, YJST, I'm sure I'm butchering that, new member, and thank you for your generosity. Kay Schmidt is a new member. I recognize that name. I think she was a member before. Mudbug, continued generosity. Thank you. Nordic Phoenix, thank you for your generosity, and we addressed your comment as well. Thanks as usual, Dr. Vonda, for your generosity. Mudbug again. Aspiring court reporter, thank you for your generosity. And I did put these comments up so that Brad could see them, but thank you for these amazing interviews. So great to get such incredible insight on this wild case, hoping for justice for Rick and true justice for Abby and Libby. Mudbug again, thank you for your generosity. Crystal, I'm hooked. Thanks for your generosity. It's getting weird in Carroll County. Stephanie, thank you for your generosity. She says, thanks. Thank you for keeping us all informed. Free Richard Allen. Thank you, Lead with Love, for that update about Kathy will be approved for visits in a day or two. Glitch fixed. Glitch, huh? Kind officer found. Rick got his property back and his funds too. All right, well, that's promising. And thank you for your generosity. Thanks again for your generosity, Lead with Love. And we did address your question about competency. Bob had was something Bob wondered as well. Jamie Dawn, thank you for your generosity. You're phenomenal, Mr. Rozzi. Truly, you too, Bob and Allie. Thank you. Precoscent, new member or returning new member. Ariel, she's been for 10 months. Why did he have sticks? That's a question that she is talking about Weber in his garage. And I mean, it was the question of the hour. Thanks again for your generosity. And I did put that up. Your thank you to Brad. Scorpion, thank you for your generosity. I couldn't ask all of your questions, but he was asking or she was asking, do you think if you guys walked, if the defense team walked when Gull fired them, would anything have changed? Would she have allowed third party prayers for Richard? I don't think so. And I can't imagine they think so either. Civil Rights, thank you for your generosity. She's indicating that the Iowa case is not solved and Michael has the info. The girls were found in Indiana. All right. Thanks again for your generosity. Retraction found 25 miles away from Iowa, not in Indiana. All right, guys. Well, thank you all. And don't forget to like and share and comment. And if you're on the replay crew, you guys too. I have no idea how many likes we have right now. There are almost 1,200 of you left. Just minimize that chat. Hit the thumbs up before you leave. We would greatly appreciate it. And it's free. Yay. All right. Thanks, everybody. And go watch Bob and Hughes, I guess. Go on Court TV. This should be interesting. I almost think that Bob should have declined to go on with him at the same time, but I didn't have time to think about this. I didn't know it was even happening. Thanks again, everybody, and see you next time. Bye. How do I hit I think this will do it. Hopefully I get the outro with this. Well,